Hey, what, Shannon?
Evening.
How's it going?
Yeah, good. You?
Yeah, good, thanks. Just you and me tonight. Will's under the weather. There's a little bit of a not COVID going around, cold or whatever. Um, Welcome everyone. Um, there's no questions coming in through the live chat yet. Oh, hang on a minute. Oh, nearly saved it. I was going to have some feedback going on there. Yeah, guys, the usual stuff. So please don't put personal information into the live stream, into the chat. Just ask it questions as if they're about someone else. This isn't legal advice. And the live chat will go down at the end of the live stream, so the recording won't have the chat. So just bear that in mind if it's relevant. We've got three questions that have come in. Well, two questions that have come in during the week, and then one other that I'm asking or answering, which is about gatekeeping. Just a little bit about on that. So we're running a free online event 3 weeks today. Same slot, so there's not actually going to be a live like a Q&A that week, but you'll have to live with that. Basically, panel discussion. So me, Shannon, basically the three really kind of cool lawyers and someone called Marnie Burden, who's a trusted expert link among other things. She wears lots of hats. So Giles Peaker, Professor Luke Clements, and Sarah Steinhardt are all due to be coming. And we're going to be exploring this issue of gatekeeping, which is why I'm going to start in a minute talking about the definition of gatekeeping, because yeah, people don't always know what it actually is, and it's actually a little bit more than people might realize. So yeah, let me put in well, in a second I'll put the link into the live chat. So there's an Eventbrite, as I say, you just got to register. All that's going to happen is you come back to YouTube. So actually, you don't need to register if you're a regular, because you'll just pop up at 7:30 on that Thursday, and it'll be the event rather than just us two and Will. So but I think the reason I'm saying this is in my opinion, it has the scope to do a lot of good. Um, Obviously, gatekeeping's an open secret in the homelessness sector. Loads of people know about it. Loads of people whinge about it. But no one really kind of knows quite what to do about it. And I'm hoping that in this event we can actually provide some food for thought and some clear kind of actions that people can take in different roles. And for me, there's a role for everyone. So whether you're a housing officer or whether you're a member of the public or a charity worker, whatever, you have a role to play in all this. So yeah, it should be good if we pull it off, which is not a guarantee, but we'll go give it a good go. So yeah, what is gatekeeping? You might see the video I put up a couple of weeks back saying about what do you think about gatekeeping, and some people have been following the channel for some time. We're like, well, that's a bit of jargon there. Actually, I don't know what you're talking about. What is gatekeeping? So if we try and explain what it is now, I'll start and then Shani can fill in the gaps. In short, gatekeeping is where a council blocks you from accessing the assistance that is owed to you under the Housing Act. We obviously talked a lot about what assistance is available to you under the Housing Act, and councils are known to systematically deny those rights or block people from those rights. And that's often in the form of telling people, go back to the area where you've got a local connection to and not taking a homes application. You might be telling someone that they're not in priority need without actually issuing that in writing. So, it's not actually worth anything. Or telling people things like you're intentionally homeless, there's nothing we can do. Those are kind of classic or the kind of the best known types of gatekeeping. But there's actually some more subtle forms of gatekeeping, which housing officers themselves won't necessarily know about. A really good example of this is around the difference between Part 6 and Part 7 of the Housing Act. So if you are homeless, you would understandably go onto the council's website and it will probably tell you to fill in a form. What it doesn't tell you is that that's actually a Part 6 application form. Although, as we've said before, if you're telling them that you're homeless or you might be homeless or you might be threatened with homelessness, they should treat that as a homelessness application under Part 7, but they don't. That's the problem. So you'll have people who they're experiencing domestic abuse. They go on the council's website, they fill in the form, they tick domestic abuse in the box somewhere, or they tell the council, this is why I'm looking to get housing help from you. And the council don't do anything with that. They just treat it as a Part 6 application. So eventually, once they process things, they'll get you banded. And, months or years after that, you'll actually get proper assistance. Whereas what should happen is the moment you say, I'm experiencing domestic abuse, that's reason to believe you might be homeless, might be in priority need. So they should offer you interim accommodation immediately. And that failure to do so is also gatekeeping, as another type of gatekeeping. Gatekeeping often surrounds that kind of that crucial Section 188 interim accommodation duty, but isn't just restricted to that. So, and with it, and this is actually not the definition of gatekeeping, but I'm going to talk about it anyway. What the event is also going to start talking about, or creep into talking about, perverse decision making. So where you've got someone who's obviously in priority need and vulnerable or whatever, and the council says, oh, there's no reason to think you might be in priority need, and therefore they deny Section 188 accommodation. So those kind of decisions, bad decisions. So telling people they're intentionally homeless when they're not, telling people they're not in priority need when they are. That's all what I would say is in the scope, because it's the same pressures that cause both kind of phenomenons. So council staff are, they've got caseloads of 100 or whatever. They don't have the time to actually treat you lawfully. Now, question that we'll be tackling at the event is, well, is that all right? Do they just kind of shrug and say, well, there's nothing I can do about it, or is there some stuff they can do about it? You probably guess what I think on the matter, but we'll hear from other people about that. But yeah, so the kind of the lots of this kind of stuff is there because council officers are under pressure, explicitly or implicitly, to not house people who they know there's a duty to house. So, all these different techniques that are used, it could be a case of potentially even offering temporary accommodation, which is 200 miles away, knowing that people are less likely to accept it. I would say that's within the ballpark of what we'll be talking about at the event, because it's all about, where council should do better and they don't do it because they are trying to avoid housing duty because they don't have any housing stock. That's the reason for it. So, yeah, Shannon, have I missed out anything in any of that? I feel like I've actually ended up kind of saying quite a lot.
I mean, I don't want to spoil the event, but I'd also sort of urge people to consider again the wider sort of constructs of gatekeeping that, isn't technically gatekeeping, but is more like third parties gatekeeping. So, your verifications, your now medicals, your all of the people, even housing associations to a certain degree, all of the people that the local authority might sort of contract out services to, and the gatekeeping that happens there is again doesn't quite fall into the technical definition, but it all has a knock-on effect on the person's, homelessness application process. But yeah, I don't
Yeah.
want to spoil the night, so I'm not gonna.
That's cool. Yeah, that's cool. Yeah. I think that's you're absolutely right to raise that. I mean, as we said before, verification can be unlawful if it's a council officer doing it or involved in it or knowing about it. But often what councils do is they put these buffer organisations between them and the homeless person so that they don't, you don't have these legal duties arising. So yeah, that's what gatekeeping is. I'm trying to think. I think we've missed anything, but it's all that kind of structural stuff. And the reality is that for people who are being gatekept, they might not know, the specific, section of the law that's kind of not been followed, but they tend, in my experience, to have a really good understanding that they've just been screwed over. So they'll leave the council building upset, distressed, angry, distrustful of services because they feel like they've just had the wool pulled over their eyes. But as I say, they don't have the specific legal knowledge to actually pinpoint what's actually happened. So yeah, just we've got two more questions to do, guys. I've just had my some root canal treatment done, so I'm not looking to stay longer than I need to tonight. But if we don't get any questions in the live chat, it was going to be a pretty short night. So next question we've had in the week is, do I have to pay rent for interim accommodation? I heard people paying nothing for interim accommodation after arguing. Is there a case for not paying? It's so expensive paying hotel rent, which is a fair point. So the answer is yes, you're liable for some sort of cost. I don't know if it's right to call it rent or what. So, nightly costs, or I don't know. Yeah, some sort of money you have to pay to stay in interim accommodation. And often the types of accommodation that councils use, like hotels, like nightly lets and so on, are incredibly expensive. The key thing, and it seems that some housing officers don't even realise this, is that any accommodation they offer you has to be suitable. And as part of that, that means it has to be affordable for you. So in some cases, you'll pay all the rent because you can afford to pay all of that money, that cost or whatever. In other cases, and I've mentioned this several times now, so I'm sorry if you keep hearing me repeating it, but so I worked with a guy who he owned half a house and was going through divorce proceedings. Domestic abuse was involved basically, and the council had an absolute duty to house him, but he was not eligible for housing benefit because he had this asset, and it was going to take ages to actually get it sorted out. So the council's duty was absolutely they had to provide suitable accommodation, and in that case, what they had to do was essentially pay the rent, or almost. I think the rent was £1 a month in the end, so he had to pay £1 a month, but they paid the rest of it, and it didn't come from housing benefit; it came from a different budget. Now, that's an extreme, but you're often going to have situations where you can't afford the full rent. And what the council will need to do is they will need to work out how much you can pay and still have enough left for your reasonable living expenses. And bearing in mind, in a lot of B&B type accommodation or hotels or whatever, you won't be able to budget your food very well because you can't cook. So you're going to struggle to kind of eat properly if you're not paying more than you ordinarily would for food. So the council should look at that and basically do some calculations, very similar to the calculations they do around establishing whether someone's in affordable accommodation and whether they're homeless because of it or whatever. But they should be essentially making sure that that is affordable for you. So it's there's a kind of very complicated way of looking at it. But if you feel that you are having to pay more than you can really afford in the circumstances, which is very probable, you can go back to the council and say, I can't afford this. I can afford, this amount. And then you probably have a little argument with them about what you can afford and what they think you can afford. And then they need to either find cheaper accommodation for you, or they need to top it up from a budget in the council, whichever one that might be. So you do have to, you are liable for rent. You'd also have situations where potentially you might be liable for two rents at a time. So say, for example, you're joint tenant, you're fleeing domestic abuse, you're now in temporary accommodation, interim accommodation, or whatever stage. You might be still have to pay the rent on your joint tenancy, depending on whether you want to give it up or not. You'll be advised not to, which is stupid in my opinion, but that's what a lot of services would advise, is that you don't give up, even if you've got no intention of returning there. So you might then go for a kind of a dual housing benefit payment, which could potentially cover two different properties, but there's going to be times where it just doesn't kind of fit the mold. So you as I say, it's got to be affordable. The council has to basically provide that accommodation and make it affordable if it's not on paper. So that's in terms of I don't actually quite know how they kind of actually do the payments and stuff. Housing benefit would normally cover it, but I don't know who you'd have to pay. You might have to pay a different organisation than the council because it might be provided by a third party. It probably will be. So you need to arrange payment for it. But that's, I think, kind of my answer to it. Shannon, have you got anything else to add to that?
Just to say, in most cases as well, they can backdate the payment. So if actually from day dot you weren't able to afford it, and then you make that case, then 9 times out of 10 they will be able to backdate that payment. So you'll be covered. I'd also sort of add that, potentially there's other ways that you can get that help, but everything that they need to say is in writing. So I worked with a couple of clients who were under sort of closure orders, and again, so they were liable for their rent at home and TA. And actually, the letter that was provided was really good. Like it explained everything and explained what to do. So if in doubt, check the letter, ask for the letter about, sort of rent costs and stuff. It's often a chaotic time. I remember the first time I went into TA, I received like very little paperwork. So it's not necessarily, do you know what I mean? There's a little bit of leeway and give there, and you can go to them and ask for that paperwork and say, look, I need some help. And like you said, if you genuinely can't afford it, there are solutions there.
Yeah, I mean, I've not seen it myself, but I've heard of housing officers telling people that you don't come to us, we can't help you because the hotel's going to be really expensive, and they put people off again. That's, I guess, another form of gatekeeping, where they're trying to put you off actually going for it. Little related, so just on that as well, just as always, have those conversations in writing. Don't it's a legal process. You don't want to be leaving anything. If you're not sure about something, email the council and ask the question, because even if they take 6 weeks to respond to you, you can say, I was on the ball. I asked you this 6 weeks ago and I didn't get a response, but I've acted reasonably. Don't stick your head in the sand, as difficult as it might be, given how much you're going to probably be going through at that point. That's what you want to be doing. And just a related, just made me think of something. So it's kind of funny. I worked with a guy a couple of years ago. He was in temporary accommodation for, I don't know, between 6 and 9 months till he got his social housing tenancy. But when he moved out, the third party landlord tried to absolutely stick it to the council in terms of charges. So then which were then put to him. So basically, they were trying to charge him tried to charge him 80 quid for disposing of a mattress, which was there when he got there. And also, all they did was they kind of took it downstairs and fly tipped it on outside in the kind of forecourt, which he was able to prove. And there's a whole load of stuff which just wasn't, just reasonable wear and tear. It wasn't like he damaged the property like so. I think he got a bill for a few £100s. And actually, when we challenged it, went back, first of all, can we have some photographic evidence of this damage he's supposed to have caused? And they didn't have any. And then the other things that we kind of just argued them down. So I think he ended up having to pay like 20 or 30 quid or something. But I've seen this elsewhere in some of the Facebook groups where if you're getting that kind of charge, challenge it. If assuming it's unfair, just challenge it, because, as I say, these third party contractors and landlords may have a tendency to kind of exaggerate costs and stuff like that to maximize profits. So you just need to make sure you stick up for yourself, basically, again in writing. So I guess the absolute textbook answer would be, when you move in, take photos of everything or take a video of everything, and then when you move out, take photos and videos of it again. That's probably unrealistic to do in the circumstances, but that's probably a good, if you have got the capacity to do it, that's probably not a bad idea. So yeah, that's that. Still no questions on the live stream, so we've got one question left, and if we haven't got any more questions, we'll be calling it a night. So, and this is, I actually don't know the answer to this question, but it'd be interesting to talk about it. So, quick question: when my housing officer closes my case, even though I'm still homeless, how long will I have to wait to reopen a homelessness application? As my housing officer referred me to an agency, picked out a flat, but I rejected it as it was too far. So now he decided to close my homeless application. So now this came through one of the YouTube video comments. So I went back and said, were you in priority need? And this person, I'm not sure if male or female actually, but they said, that they were not in priority need. So what I don't know the answer to is, if you're not in, if there's no reason to think you might be in priority need and you haven't, you're still not in priority need, I'm not quite sure how this would work. But let's start with what we do know, just to kind of make it easy. So if you are, you make a homeless application, let's say you're eligible for assistance, so you've got recourse to public funds. There's a number of permutations of what can happen. One of the things that might happen is you're found to not be in priority need. And so if they did offer you interim accommodation whilst there was reason to believe you might be, that will end a few days later, and then you'll be still under the relief duty, but you won't be offered any more. You won't offer a roof over your head. And what the council will do is stuff like what they probably try to do here is try to find you accommodation, but it could be, very unsuitable, and the suitability rules don't really apply to this sort of area of the law. So they can say, look, we've taken reasonable steps to try to house you. We found a flat for you 50 miles away or whatever, and you rejected it, so it's on you. Now, if it was a non-priority decision and your health then deteriorates or something, or other circumstances change, you can make a fresh homelessness application, provided your application is not based on exactly the same factors as the previous one. So let's say you're completely, fit and healthy and robust when you made the first application. They found you not in priority need. They didn't take any reasonable steps, or they didn't take any successful steps to get you housed. You're now homeless, you're sofa surfing, or you might be sleeping rough. Your health is almost certainly going to be taking a downturn. And it might be as a result of that you develop some issues like depression or anxiety or something else along those lines. Now, you can make a fresh homeless application if you have something to tell them that they didn't know in the last one. And it could also be a worsening of your health issues. So say let's say you're prescribed 50 milligrams of sertraline on the first application, and you found not in priority need, which is, I guess, possible. It depends how the depression's acting on you at the time. And then you're then homeless and your depression worsens and your GP ups your dose to 100 milligrams. Then that is a change of relevant facts, which is more than minor or trivial. So you can make a fresh application, and they have to decide again whether you're in priority need. So that's the easy part of the answer. There's another permutation which is worth saying, where you're found to be in priority need, but you're also found to be intentionally homeless. And let's say that you actually are intentionally homeless. So let's say there's no challenge that you can plausibly make. So council has to house you for another another month or so after that decision under Section 190, and then they end that duty. You can appeal for longer in terms of staying in temporary accommodation in that circumstance if there's just really nothing out there, but you're not going to get a long extension really. So let's say you're homeless again. Now you're intentionally homeless effectively until you're able to secure settled accommodation and then lose it again. And so, whereas I said, so the change in facts, it has to be a change in relevant facts to make a fresh application. So it might be that you become homeless and you're even more vulnerable now than you were before because your circumstances are grim. But that's not a relevant fact because they already accepted you're in priority needs. But what they were saying before is that you're intentionally homeless. So unless there is a change in relevant facts, as in there's something's happened that means that you might not be intentionally homeless anymore, then you can't make a fresh application to that council anyway. That opens up another thing as well, but I'll talk about that in a minute. Now, the courts have found that there are some things which could count as a change in relevant facts around intentionality, which is not gaining settled accommodation. So there was a case which I always get wrong. I think it's Fahia, Fahia, and I think it's versus Hillingdon or Hounslow or one of the H's. What else is around there? I can't remember. Some of the sort of northwest London or West London places with the H. But yeah, basically that happened. So the family were in a B&B in temporary accommodation. They were found intentionally homeless. The council ended their duty, but they were able to stay on in the B&B and they stayed there for another year. Now B&B is obviously not settled accommodation, but then they went to make a fresh application and effectively they won the argument in that sense that something had happened which might have changed the outcome of the application so they can make a fresh application. Now I don't actually know what the outcome of the application was. I suspect that they would have said they were still intentionally homeless, but you can make a fresh application in that situation. I just opened up a can of worms with going to a different council because you can do it. If you go to a council where you might have local connection to more than one area, so you could go to another area and go through that process with them and basically hope for a better outcome. Hope you might be able to present information that wasn't available the first time, whatever. But if you don't have local connection elsewhere and you approach a different council, they have to accept the initial duty under Section 184 and the duties under Section 188 if they apply in terms of offering interim accommodation. But they very quickly will refer you back to your home area after a few days, basically. So as an absolute kind of shot to nothing, get a roof over your head in an emergency, it's worth doing. But in most cases, it's not. But that brings us back to this question of, well, what if you weren't in priority needs and there's nothing to suggest you now are? When can you make a fresh application? As I say, this is the thing I don't know the answer to. I don't. I'd have to go away and read up about it basically, but because I don't. I think in one sense the change in relevant facts is really looking at that 5-part test. They're looking at priority need, they're looking at intentional homelessness, they're looking at whether you're homeless at all, potentially. But I don't see anything outside of that that would mean you can make a fresh application and get the relief duty again. Now, councils can offer, I'm sure they can offer their operate some discretion there and accept a fresh application under the relief duty as a non-priority person and see if they can again try and assist you into some sort of accommodation. But I don't think, I don't know. I'm not sure. It's a very obscure question, but it's actually a very good one. It's one that's only come in with the HRA. He's been around for 5 years now, so there's not really much of an excuse to not know it. But I think, yeah, that's my lack of an answer anyway. I need to go and read up on it really, or put a question in the Facebook group about it.
I feel like part of that Farley case, because that was the one I was going to mention. I feel like part of that was the time period, and I feel like it was either 9 months or 12 months, and they'd basically wait, and the judge said in that it was the time period that allowed the fresh application. Now, so I don't know if it would be the same, whether you could apply that and say, actually, look, after X amount of time, and those times would look different, I would assume, because rough sleeping should be a shorter time to being in a B&B, for example, So almost after a set period of time of rough sleeping, actually that's been a long enough time for situations to change, things like weather changes, so things that aren't relevant potentially could allow you to make a fresh application. But again, I don't know.
So it's Yeah, I've just checked it. So it's Harrow, the other one with
Right.
a H. But yeah, but so I think yeah, it's a really good point with rough sleeping. Now, something that I put in the Facebook group, didn't get a response actually, but in the Welsh Code of Practice, Code of Guidance, basically it says something along the lines of people who are rough sleeping are likely to be vulnerable because of their social and health circumstances. I might be able to find out what the wording is if I'm really clever. But basically, and my question in the group was, well, given the definition of vulnerability within Welsh and English law is almost the same, wouldn't that be good evidence for you to go to a council and say that actually, the rough sleeping group as a general rule are likely to be in priority need? So you'll see this around um, sort of verification process is a good example where people who approach a council and they're told to go and rough sleep because they're kind of said, well, there's no reason to think you might be in priority need. Well, if the Welsh Code is saying that people who are rough sleeping are likely to be in priority need, then that should certainly get us a long way to kind of showing that there's reason to believe they might be in priority need under English law. Um, so yeah, I think yeah. So in a situation like that where you remain in a vulnerable situation that's going to have an impact on your health, then yeah, as Shannon says, actually, it wouldn't take long. And I think I would say in a few weeks, within a few weeks, you're going to be ground down a little bit. You're going to probably been targeted from exploitation from somewhere. So those sorts of things might well kick in. And risk of exploitation, by the way, is another factor that would be relevant to vulnerability and priority need. So I think, yeah, that I don't remember anything in the code of guidance which speaks specifically about this idea. I mean, the other kind of options open to you at that point would be to go into supported accommodation and try to go through the system in terms of staying there long enough to get a banding on the housing register and just waiting. But yeah, that's obviously got some drawbacks to it as well. So yeah, I mean, again, it's kind of down to the risk you take when you turn down council accommodation that they've offered, particularly under the relief duty. Because as I say, again, I need to check this out actually. It doesn't have the same kind of doesn't need to be to the same standard that a normal discharge of the main housing duty would need to be. Certainly in terms of like the length of the security, and technically, yeah, it's a bit of an unknown area. I don't really I don't really kind of work within the relief duty particularly. I don't find it terribly useful. I know Will does because he can kind of use some fairly complex arguments to kind of make a point, but it's not quite the same for me. So yeah, I don't know. I think that's kind of a that's certainly an answer. It's part of an answer. Whether we can find something better, I don't know. Um, anyway, well, that brings us to the end of our set questions from the week, and there's no questions in the live stream tonight, guys. So I'll give you another 30 seconds or whatever. But if not, yeah, do check out the link on Eventbrite. I think, yeah, I put it in the chat. I'm assuming I'm going to put it in again in the chat actually because I don't know whether people who've just joined can actually see it. I don't know quite how it works with Zoom. You can't see it after that. So if I do that, that should, yeah, there we go. So that's the link to the Eventbrite for the event for the Ethics of Gatekeeping event. Do feel free to share it with anyone you know. So I've been emailing local politicians today with it, saying you want to come along to it because it's free and it's relevant to your work. So if you've got any politicians local that might need it, even send it to Richard Fuller, who I've never actually spoke to before as an MP, but certainly the local councillors I have, so I've sent it to them as well. But yeah, I think yeah, could be a significant event, I'd say. Shannon, anything else we want to say at all? We've got spaces on the 8th of December for our training, and then the next one is the 19th of January. So yeah, the 17th of November is full. But yeah, just check out the links on our pages and whatever you'll find them.
And Mike is right. You don't have to sign up to the Eventbrite. It does
Yeah,
help, just like with the numbers. So it is free. So if you don't mind,
yeah,
you don't have to. It is YouTube live. So like Mike said, we'll be here live again. But yeah.
yeah. But if you're sharing with other people, it's helpful for us to send the Eventbrite, and also on the Eventbrite, there's all like the bios of the panelists. I just to say the panel's really cool. I'm interested to see how outspoken they're going to be. But yeah, okay. Well, there's no more questions, so we are going to call it a night. We'll see you next week. Hopefully, we will. Keep the questions coming in on the YouTube channel, and yeah, 3 weeks to go to the ethics event. So hopefully we'll see you there. Take care, guys. Bye bye.